All right, everyone, so why don't we get started? A few people may still trickle in if they're on their way from class, but this way we'll maximize the time we have for this lunch event. First of all, I want to welcome everybody to the third Human Rights in Practice event of the spring 2025 semester, titled Food and Water Security, Economic, Social, and Cultural Rights in Practice. As always, Human Rights in Practice events are co-hosted by the Center for International and Comparative Law and the International Human Rights Clinic. Today's event, we also have several co-sponsors: the American Constitution Society, the Duke Environmental Law and Policy Clinic, the Duke Environmental Law Society, the Duke Human Rights Center at the Franklin Humanities Institute, the Human Rights Law Society, the International Law Society, and the National Lawyers Guild. Today we're joined by two guest speakers online, Dr. Seree Nonthasoot and Dr. Mara Tignino. Each of them will speak a bit about their work on economic, social, and cultural rights, and specifically on the rights to food and to water. And then we'll turn to a Q&A with all of you in the audience. Unfortunately, our third speaker, who is supposed to join us today, Duke Law Professor Aya Fujimura-Fanselow, is not able to join us for today's event due to an accident. Our first speaker today is Dr. Seree Nonthasoot, who's joining us from Abu Dhabi. Seree serves on the Committee on Economic, Social, and Cultural Rights, the United Nations treaty body tasked with monitoring the implementation of the International Covenant on Economic, Social, and Cultural Rights. He's also an advisor to several ministries in Thailand, and before joining the Committee on Economic, Social, and Cultural Rights, he was appointed to represent Thailand on the Association of Southeast Asian Nations Intergovernmental Commission on Human Rights. After Seree, we'll turn to Dr. Mara Tignino, who's joining us from Geneva. Mara is a senior lecturer at the Faculty of Law and the Global Studies Institute at the University of Geneva. She's also the lead legal specialist of the Platform for International Water Law at the Geneva Water Hub. She's worked and published extensively on the right to water, international water law, and crimes against water. We're very lucky to have both Seree and Mara with us today, given their really rich expertise on the topics of today's event. So to both of you, we're very grateful that you're here to share your expertise with us. And with that, I'll turn the floor to you, Seree, to get us started.
Thank you. Well, in fact, I'm in Bangkok right now, and it's...
Oh, I misunderstood. Sorry.
Way past midnight. I just traveled back from Geneva. Our session just ended on Friday. We had a nearly 1 month session. Let me pull out the file that I'm preparing for this discussion. I have about 15 minutes, and then I'll hand over to Mara. And it's great to make your acquaintance today as well, Mara. Unfortunately, we didn't meet while I was in Geneva. I'll talk about the work that I have been doing. This is my second term with the CESC, the Committee on Economic, Social, and Cultural Rights now. I think we need to start by looking at the covenant itself, which is a human rights treaty as part of the International Bill of Rights. At the moment, as we speak, there are 173 we call country state parties. They are obligated to submit reports periodically to the committee comprising 18 members who are represented in geographical terms from 5 geographies of the world. So 18 of us, we divide the work among ourselves to monitor and to engage with state party when they submit their report to Geneva, and when they appear to have what we call constructive dialogue. So they gather or they compile a team comprising different ministries and agencies to respond to various points on economic, social, and cultural rights. You need to understand also that we are part of a larger ecosystem. As I mentioned, the covenant, as we call it, has a sister, the other one being International Covenant on Civil and Political Rights. We also have thematic or specific phenomena conventions and specific group conventions having to do with issues like racial discrimination, torture, enforced disappearances, women, children, migrant workers, and persons with disabilities. And these are all interconnected. And a challenge here is how we can synergize our work, not to, although I tend to use the term complementarity to reinforce the notion that whatever we do will have ramification beyond the room that we're in with the state party. So when we in fact examine, for example, the issue of non-discrimination, we always cover persons with disabilities, LGBTQI plus individuals as well. Now, uh, looking more closely at the covenant itself, it contains a number of provisions, but on screen, these are the key substantive provisions of the covenant. So there are about 14 substantive provisions. We divide these provisions into 4 clusters for the purpose of our working when we interact with state parties into 4 clusters. I'll mention them subsequently. But here I like to mention the 4 most important principles. Of course, number one is non-discrimination. And this particular provision has given rise to a number of general comments, a number of our points that we have raised with state parties. Normally, on non-discrimination, we encourage state parties to develop and to adopt a comprehensive non-discrimination legislation. In many states, there are specific legislation having to do with certain group. For example, in Thailand, um, since nearly 10 years ago, the Thai government introduced a law to prohibit sexual discrimination. In Geneva, the committee, while commended Thailand, has issued a concluding observation to encourage Thailand to adopt a comprehensive non-discrimination legislation. Another principle is equality between men and women, which we have used to cover sexual orientation as well. Now, the other two are twins, and they are Article 11 and Article 12, which serve the purpose of our discussion today. Article 11 establishes a floor. So I call it a floor because it is adequate standard of living, so the minimum standard. And the other is a ceiling, the highest attainable standard of physical and mental health. These two are perhaps the most dynamic provisions of the covenant. And you'll see later on how it has given rise to legal foundations for a few rights that are not specifically or explicitly mentioned in the covenant. So before we move on, I like to mention also 2 principles which are not stated here, but they are stated in the provision. There are maximum available resources, or MAR, and the other one is progressive realization of economic, social, and cultural rights. We know that when a government relies on resources to enhance or to progressively implement or recognize or realize economic, social, and cultural rights. That's why we have enshrined the notion of progressive realization. With these, let's move on to C. Now, for our purpose of discussing water and food, look at Article 11, the floor provision. Uh, the, the terms are adequate standard of living for himself and his family. Specifically, the term adequate food is mentioned here, but you don't see anywhere the term water. So where does water come in into this equation? So uh, now we say that the key term is including. So the floor is adequate standard of living. We were able, the drafters were able to specify back in 1966 when the covenant was drafted, these itemization. But water was not thought of, but it was thought of by the term of including. So by using the term including, the CESC has been able to establish the fact that this standard of living, which must be adequately provided, includes other terms as well, including water. For 12, this is the ceiling, as I mentioned. Highest attainable standard of you have 2 terms here, physical and mental health. It's not just physical, you need mental well-being as well. So these have given rise to many terms that are not explicitly mentioned. For example, beyond water, we have the term like land. Where does it feature? In this floor or ceiling provisions? No. What about um, even sustainable development is not featured here, but we are working on a general comment on sustainable development. So the legal foundation is very crucial when we want to establish an understanding or a general comment. We normally base ourselves, if not other provisions, this one, 11 and 12, are strong bases for our foundation. Now, I mentioned clusters. When we look at a situation of a state party, we often divide the situation into 4 clusters responding to our provisions. So cluster 1 cover non-discrimination, equality between men and women, and such emerging issues like climate adaptation and business and human rights. In cluster 2, it features labor issues, trade union, and just and favorable conditions of work. Now on screen, you see that toward the end of the screen, the bottom of the screen, I have noted various general comments that have been established based on that particular provisions. Often, it is clear as to the legal foundation on which we base our general comment. Like, Article 6 talks about right to work. Of course, general comment on the right to work bases itself on this particular provision. I myself and a group of colleagues are working on a general comment on drug policy. Now, it's quite challenging because drug policy is a cross-cutting issue. And another group of colleagues are developing a general comment on economic, social, and cultural rights in the armed conflict situation. So, of course, these are cross-cutting. These cross-cut and has overlapped relevance throughout the provisions of the covenant. Cluster 3 covers 10, 12, 11, and 12, as you see, the floor and ceiling of this provision, and perhaps the most dynamic one. Normally, when talking about drug policy, people would think that the focal point would be Article 11, adequate standard of living or health, because of the impact that the punitive approach to drug policy in various countries has had on the health situation of people who use drugs. But the drug policy has impact beyond these. Cluster 4 talks about education and right to culture and scientific progress. This is often neglected. But when talking about food or water, you can't deny that culture has a role to play. Water and food serve as instrument of cultural identity and scientific progress through which you can have accessibility and participation as well. So these dimensions have not yet been much explored. Now, the committee comprising 18 members have these 6 missions. Some of these have not been exercised during my term. Normally, we focus on reporting procedure and including follow-up in numerical 1. On individual complaints, these focuses on complaint communication procedure that I will mention later on. We haven't had country visits, we haven't had inquiries, but we do have general comments and organization of various general discussion. We haven't had early action or early warning. So some of these are our mainstay, some are written in the book but haven't been exercised. Let's talk about general comments because they relate to what you are going to discuss more, and Mara will help expand with her experience. At the moment, the CESC has developed 26 general comments, the latest of which is general comment on land. As I said earlier, land has implication beyond one single provision. It covers many provisions, including right to food, because it's the basis of food production, but also on water as well. In 25, General Comment 25, which we adopted in 2020, we talk about science. And in 24, this is very interesting. The CESC established a nexus of the economic, social, and cultural rights with the responsibility of business enterprise or business and human rights, which the Human Rights Council adopted the guiding principles on business and human rights back in 2011. We helped expand and provided guidance to states that one of the things that we require is the conduct of mandatory human rights due diligence. It will have implication when we talk about food and water as well. I won't mention other general comments now, except the 2 that we are going to discuss here. Now, we have issued the CESC before my time, pre-millennium, one of them, which was right to adequate food. You can see the fonts, which are pre-millennium, in 1999. The other one is post-millennium on the right to water. For the right to adequate food, one of the key issues that the committee expects state parties to conduct vis-a-vis this particular right is the development of national strategies on food and adequacy provision of food in their territory. Water as well. But I like to tell you the year has great meaning and great consequence because these two general comments have served when they develop the SDGs that I like to pull out in a minute. But let's digress just for a moment to talk about communication procedure that has been established via the optional protocol. One of the issues that has had surrounded the CESC or the International Covenant on Economic, Social, and Cultural Rights was the lack of justiciability mechanism. This has subsided in 2013 when the optional protocol came into effect. And right now, there are 31 state parties to the optional protocol, meaning um, we can receive communications arising from the provisions of the covenant of from that particular country or state party. But I'll have to tell you that on food and water, we have not received any communication based on these two issues. Most of the communications that we have received pertain to housing, as you can see, and mostly having to do with one particular developed country. Um, so, and of course, it's a matter of time before people realize that they can use this remedy to provide them with effective redress in international law as well. Now, back to our substance. The SDGs often have impact, of course, and we look at the SDG progress in our examination of the situation of countries. Whereas Article 11 and 12 and our general comment have strong legal basis. The SDGs are a policy instrument, but it has one clear difference, which is very beneficial: a monitoring and a monitoring mechanism there, and shows the result of each state parties or country when we talk about targets and indicators here. Um, and during the time of COVID, of course, one of the things that we often talk about when we mention SDGs is the interdependency and interrelatedness of various goals. And you can't, I will be remiss not to mention this, that the majority, if not all, of the SDGs are based on economic, social, and cultural rights. Of course, you see 16 also based on civil and political rights, but we also have common provisions having to do with non-discrimination as well. So it has relevance to both um, both covenants. Now, the when we have we don't necessarily mention food in every periodic in every corps we call concluding observations corps because it depends on the situation from country to the next. But when it merits to be mentioned at all, we often cite our own general comment and cite the key elements of that general comment. For example, we often talk about how a country in COVID situation neglect to provide food or sustenance to its people, and we urged because of the lack of that assistance, the adoption and development of robust food strategy in that particular country. I like to, because time is limited. Let me see. Okay, I'm way over time now a little bit. I
It's
just want to
okay.
mention this one, that the dynamics that we are seeing now is that when you focus on one right, you must not forget that a particular right always have siblings or ecosystem that is much larger than a one particular right. That's why we call human rights in plural always. Right to water and food are pretty much dependent on other rights, like this one. The rights that have been recognized by many treaty bodies and special procedures, and including the General Assembly. In 2019, the right to human rights and climate change has been prominent right now. So climate change is a debilitating factor that affects food and water, of course. So, and I like to mention also that there are um, actors beyond state, or we call them non-state actors, especially businesses. But in other instances, there are paramilitary groups. There are, uh, uh, you know, beyond these groups, there are minority groups that use forces as well. So we uh, often urge them in climate change term to holding them accountable for harm that they generate both domestically and extraterritorially. Um, Perhaps just want to tell you that during COVID time, we issue statements. Um, I have to tell you that it's quite difficult to come up with um, a general comment in a speedy manner. So sometimes instead of a general comment, which is a fully fledged explanation or thesis like a work containing, there are word limits to a general comment of 10,700. Uh, a few times we have developed this and issued this statement. The latest of which that we just adopted last week has to do with fiscal policy or taxation policy. Uh, I like to leave you with 2 points. One is the dynamics of business and human rights that you need to examine when you talk about food and water as well, because oftentimes it's not states, only states that have impact. Businesses have greater impacts many times, including in an extraterritorial area. And the other point is this one. We often neglect to talk about how we execute, how we implement, how we monitor progress, what kind of indicators, what kind of indexation that we have used. And it is actually human rights indicators. But we don't, this one is a little bit outdated, and the Office of High Commissioner on Human Rights is contemplating a revision of this one. But we use them as a guidance, and you can consult this one as well. There is a illustrative indicators on the right to adequate food. So I like to end here by saying that right to food and water is part of a much larger ecosystem. And when you talk about economic, social, and cultural rights, you must not forget other dimensions that you may have neglected before. Particularly right now, there is a deficit on the right to culture. So that dimension should also be brought into your equation as well. I'll end here, and if you have any questions, would be pleased to respond. Thank you. I'll give the floor back to Jillian.
Thank you so much, Seree, for that excellent presentation. Rather than do questions now, I'll turn the floor directly to Mara, and then once you've made your presentation, we'll open the floor to everybody in the room for a question and answer session. Thanks again, Seree.
Yeah, thank you, Jillian. Thank you for organizing this event. I really enjoyed the presentation of Seree. So now I was asked to address 3 topics: international water law, the human right to water, and crimes against water. I would like to start by giving you the context on how international water law has emerged. And what it is interesting now when we look at the history of international water law, it is that the first use that was regulated under international law dealing with international water courses is navigation. So it is an economic utilization of water that was firstly regulated by international law. And till now we can see that already in the final act of the Vienna Congress of 1815. It was in this treaty that for the first time we can see how international rivers and commission are part also, we can say, of peace agreements. And the same the same story it was followed under the First World War with the Treaty of Versailles that also established the first provisions on the freedom of navigation of international rivers and the establishment of joint commission. So the first multilateral treaty on water is back in at the beginning of the 20th century under the League of Nations. Actually, not the first two multilateral treaties on water were on navigation and hydropower, so two economic uses of fresh water. Then after with the beginning of the UN, it is interesting to see that the first organizations who started again to deal with the issue of water were two professional organizations very well known in international law, the Institute of International Law, Institut de Droit International, and the International Law Association. In particular, the International Law Association adopted a document, the Helsinki Rules of 1966, that it is considered as one of the primary source of international water law, because in this document, for the first time, navigation is considered together with other uses of international water courses. And it is interesting that it is in the Helsinki Rules that we see one of the cardinal principles of international water law that for me it is also linked in some ways, we can discuss this with the human right to water. And it is the principle of equitable and reasonable use. The principle of equitable and reasonable use, it is the right of each country to use the waters of the river that flows in their territories, but this right to use is limited by an obligation not to cause a transboundary harm to another riparian country. And what it is interesting, it is that in the Helsinki Rules, the obligation not to cause a significant harm, transboundary significant harm, was included as one of the factors of the principle of equitable and reasonable use. So the Helsinki Rules of the 66 are considered as a reflection of customary international law. And this role we can see when we compare the text of the Helsinki Rules with the text of the UN Convention on the Law of Non-Navigational Uses of International Water Courses. So this convention was adopted in 1997 by the UN General Assembly after around 30 years of work of the International Law Commission. So the International Law Commission started to work on the law of non-navigational uses of international water courses in the 60s and ended only in 1994, and then there was a negotiation for the adoption of a convention that was adopted in 1997, but it entered into force only in 2014. So you can see here the reluctance of states to accept obligation dealing with the management of transboundary water courses and the protection of transboundary water courses. And why there is this reluctance? Because this convention, and I will mention also another convention, they limit the right of states to use this shared resource that is water. And the other global convention that it is very important, and I will explain why, it is the Convention on the Protection and Use of Transboundary Water Courses and International Lakes. This convention was at the beginning a regional convention only open to the states of the UN Economic Commission for Europe, but it was amended through an amendment of 2004, and in 2016 this amendment entered into force, and today this convention is open to all UN member states and African countries, and also now begins at the South American level and in the Middle East countries outside the UN Commission for Europe are joining this convention. So why an important difference of this convention of UNEC comparing to the 1997 convention, it is that the UNEC convention has also an institutional framework. There are meetings of the parties that are able to make this instrument as a living instrument that can take into consideration new aspects, like, for example, climate change. And so now after this overview now of international water law with these two main global agreements that are framework agreements, because then we have at the global level this convention, but then we have also agreements at the basin level that complement each other. We have now in the 90s the starting of the right to water, and how now the human right to water is linked to international water law. It is linked through the principle of equitable and reasonable utilization, because also the population dependent on the international water courses, the needs of the population dependent on international water courses have to be taken into consideration. And we see now in the UN Water Courses Convention in particular that there is no hierarchy between the uses of international water courses, but with an exception. And the exception is the protection of basic human needs. So the basic human needs, it is in other terms the respect of the human right to water. So when a state uses and manage an international water course, has also to take into account the respect of basic human rights in another country that is sharing the international river. So what are if we go a little bit deeper on the right to water? So Seree already mentioned the importance of Articles 11 and 12 of the International Covenant on Economic, Social, and Cultural Rights. But I would like now to give you some elements of the human right to water. So the right to water entitles everyone to sufficient drinking water. So what does it mean, sufficient drinking water? Well, to have an idea, to have international standards, we need to look at the guidelines, at the standards of the World Health Organization, because it is the World Health Organization that has established standards on how much water is needed. And I will tell you now that what is considered, if you look at publication of WHO, there is nice picture with a pyramid, and you can see you can see how many liters do we need, and in general it is considered that we need a minimum of 50 liters to cover drinking, cooking, personal washing, and washing clothes. So 50 liters is the minimum for the personal and domestic uses. And 50 liters can go up to 70 liters if we include the sanitation aspect related to water, as well the water that is necessary to for developing cultivation for the right to food. And another aspect essential for the right to water is the safe character of water. Again, there it is WHO that has developed standards regarding the safe quality of water, so the water that can be consumed safely by individuals and community. Another aspect, it is the acceptable character of water. So acceptable means the taste of water, the odor, the color. So this also is linked, I think, to the cultural aspect that Seree mentioned. And then it must be also physically accessible, so it must be reachable by the people. And there is also the economic aspect. So the human right to water, in a sense, is agnostic about the fact of putting a price to water. But no, what the human right to water says it is that such price no, must not be must not prevent poor people or marginalized community to have access to water. And then no, the question also of the price, it is another aspect of the right to water, that is the affordability of water. And as Seree mentioned, an important aspect of the right to water is also the non-discrimination aspect. So no, the state has obligation not to ensure that all people have access to water. So, as Siri mentioned, we have also on the right to water obligation to respect, obligation to protect, obligation to fulfill. And maybe no, also related to the aspect of crime against water, I would like to say that the obligation to respect also include some provisions of international humanitarian law, like the prohibition of starvation. And then, so of course, no human rights law, it is a vertical, no set out vertical obligation, no from the state to their own citizen. But when you read no, the general comments on the right to water, you see that there are also international aspects related to the right to water. So what are these international aspects of the right to water? Are the international duty of the state to respect the right to water in other countries, and here you can see the connection with international water law. So for example, a country developing a dam has to consider if this dam can cause a significant harm to another state and is, for example, reducing the quantity of drinking water to the population. A second international dimension, it is that the general comment number 15 state explicitly that there is an obligation not to impose embargoes or other measures that prevent the supply of drinking water. So, for example, here, now if we expand our conversation, if we take the example of sanction, for example, there should be no also exemption, humanitarian exemption that allow no the for example the fact to give products to make clean and drinking and drinkable the water. Then the third aspect, it is exactly the aspect related also to the companies, to the business that Sisi was mentioning. So that steps should be taken by states to prevent that companies or citizens violate the right to water in other countries. So here there is also an obligation of states to prevent their own companies to go in the territory of another state and having an impact on the right to water in other countries. And then, so also the facilitation of the right to water. So what does it mean, the facilitation? It means, for example, the financial and technical assistance that can be given by by developed countries to developing countries. Then I would like to mention, because I think that is an interesting example, that the African Commission on Human and People's Rights has developed a specific guide for implementing the human right to water. So again, here now we can see a relationship between a universal organization like the UN and regional organization like the African Union and the African Commission on Human and People's Rights that has developed this specific guidelines. So very, very briefly, because I think that I'm already almost to so what does it mean to this concept of the crimes against water? Until now, no, we have seen the law governing the transboundary waters, the human right to water that is connected to the protection of transboundary water courses through the principle of equitable and reasonable use. But what about when it is violated the rights of people? So here, no, it can come useful to make this reference to the crime against water. So here, no, I would like to give you some examples of crimes against water. A first example, it is something that maybe no, we don't think very often, but unfortunately, it is. Quite important. It is the water corruption. So what is the water corruption? It is that there can be case of grand corruption involving, for example, political decision makers or grand investors that receive no money to give, for example, to allow concession on the use of water services. Or we can have also petty corruption, no, when people are requested not to pay to have access to water. Then we can have also water organized crime. What does it mean, water organized crime? It means when criminal organization have a control over a territory, and so with this control over a territory, no, they can limit the access to water, also prevent any use of water resources. Then we can have water pollution, of course, of rivers or groundwater resources. We can have also water theft. So water theft, it is when we have a reduction of water to have an economic advantage. Water fraud, when we use fiscal artifice in measuring, for example, water to have some illicit gain, or also what we can call as a water terrorism. So terrorist attacks, against water installation that have an impact on the quantity or the quality of water, or also water cyber attacks, so the manipulation of the information. So these are examples, and we have some international legal frameworks not developed by the UN against the corruption or transnational organized crime, but still environment, and in particular water, is not really addressed. So no, I would like to conclude by saying that I think that something that we should think about and that we need to develop, it is the role of domestic criminal law to address crimes against the water. So all the examples that I give, domestic criminal law can play a role, or also international legal frameworks like the two UN convention that I mentioned on corruption and transnational organized crimes. They have conference of the parties, and the conference of the parties are mechanisms that can make progress an instrument, and including new topics like water in their discussion, and adopting instruments that can be used for states to develop domestic legal frameworks. Many thanks, and I look forward to the discussion.
Great. Thank you so much, Mara. So after these two very rich presentations, we would love to open it up to the audience for any questions you may have for either speaker. Does anybody want to get us started? Yeah, sure. And can you introduce yourself, just your name and your year in law school? And then once you say it, I'll repeat the question to make sure the speakers have heard.
Yeah, my name is Christiana Farnsworth. I'm a 2L in the JD LLM International and Comparative Law program. And kind of picking up off of Mara's last point, I want to know if either of you know to what extent countries have already incorporated into their own domestic laws the human right to water, or in other words, to what extent can courts domestically enforce this right?
That's a great question. Thank you, Christiana. So just to make sure you guys heard, so the student's name is Christiana. She's a second-year law student here, and she asked if there are countries that have incorporated a right to water in their domestic legal systems, constitutionally or otherwise. And so are there ways of enforcing a right to water at a domestic level, not just via international law? Either of you is welcome to jump in as you feel comfortable.
Mara, please go first.
Think, yes, I think no. The first example it is the legislation of South Africa that it was really no the first country or one of the first countries to incorporate the right to water in the domestic legislation. And now I don't have the number of the countries that have included the right to water, but for example, in Europe, Slovenia has included the right to water in its domestic legislation. In South America, Uruguay has included. So there are really many countries that have included the right to water either in the constitution or in the domestic legislation or in both of them. And then of course, when you have the right included in the domestic legislation, it also gives more possibility to the individuals and communities to make use of domestic enforcement mechanism.
Thank you, Mara.
I like to add what Mara said by saying that, despite the absence of the comprehensive or omnibus right to water law, we can always rely on various provisions of the covenant, particularly non-discrimination and equality, to reinforce the notion that, even without a particular law or specific law, you can always rely on those measures to actually help enforce your own rights to water. If you are in the situation, there are so many dimensions to it, and I really enjoy Mara's speech. When you talk about international dimension, but also domestic dimension, is so multifaceted. You need to know enough landscape to map what kind of legal instruments there are. Some of these are soft law, a number of them are hard law, but the hard law part you can utilize despite the fact that there is an absence of a specific law.
Thank you, Seree, and thank you, Mara. Sure.
I'm Mama, I'm a second year as well. And I guess I was wondering for states that are hesitant or even averse to complying with the obligation to supply that floor and ceiling of food and water, kind of what are the procedures currently for getting those states to kind of fall into compliance if there are any?
That's a great question. So we have a question from Mame, who is also a second-year law student. And their question is, when you have states that are hesitant or averse to implementing the floor and ceiling that you talked about, Seree, in your presentation, specifically around the right to water, what can we do about it? Are there tools? What tools are at our disposal to push them in the right direction? Is that a fair? Okay, great.
I think there are the two dimensions of that pronoun, we. You, as you said, we. You can, of course, provided you rely on various provisions of the covenant's obligations. If that country in question is a party to our optional protocol, communication procedure is there. We in Geneva, the committee, what we do often is we actually say to state party where a default or a violation occurs, we said to them that we are not pleased with this lack of progress or even sometimes regression. And we put in our concluding observation a point that we've noticed a regression and we want some redress to occur. For example, if you discriminate against race to have access to water, that is a no-no based on Article 3. So we will put a number of recommendations and we'll put this issue, if it's a priority, weighing other, in a balanced term, other measures, other situations, designate that issue as a follow-up issue for the next 2 years. We don't wait until the next 4 years. We want to make sure that the 3 priority follow-up issues will be monitored within 2-year period, like what we did in the context of UK. And the COPs of the UK and the Philippines were just released actually today. We said to the UK, we want these three issues that we want to monitor. So the we part has different actions. For us, we keep monitor and monitor. For you as a we, if you are a human rights defender, I think there are various avenues. And don't forget when Mara said about regional mechanism, if you happen to be in the Americas, if you happen to be in Africa, or even if you are in ASEAN, you can encourage, you can utilize various mechanisms in your help. Yeah.
Thanks, Seree. Is there anything you want to add on that point, Mara?
No, thank you.
Okay, great. Thanks for that question, Mame. Other questions? Yeah.
Hi, my name's Ryan. I'm a 2L in the JDLM program with Christiana and Mame. My question is, once it comes to a point where a country is being engaged in a dialogue because they have fallen short on some sort of water or food provision, do you have any examples of countries actually altering their behavior as a result of those dialogues? We have a professor here, Larry Helfer, who's given us some examples in other contexts, but I was hoping that one of you could share some examples in the water and food context as well.
Great, thank you so much. So to summarize,
I hear that. I can respond immediately.
Okay, I'll just summarize it in case there's folks online who didn't hear it as well, and then I'll turn it right to you, Seree. So the question was from Ryan, who's also a second-year law student. He asked if once a country falls short on these obligations, on the rights to food and the right to water, are there examples of times where pushing them to do better has been effective, that we've had a result, basically? And then he mentioned that there's a Duke law professor, Professor Larry Helfer, who is a member of the Human Rights Committee, who has spoken to his students about examples from that context where you've seen pushing on rights violations lead to some direct result of improvement. And so are there examples like that from the food and water space? And I'll turn it to you, Seree. Just wanted to make sure our folks listening online heard as well.
There are quite a few. In fact, the most current, recent example happens in the case of France. We issue a concluding observation last year encouraging France to adopt a national strategy on food. And France is doing it right now. So that's a kudos to France. But I think you asked specifically about water. I don't have specific references to water, but food happen quite often because that's one of our priority area and one of the, water is SDG 6, but we have had opportunities to examine food and issue statements on food, which resulted in tangible progress. But I'll ask Mara if she has seen such examples from her side as well.
Thank you. Maybe I would like to answer not on the side of the right to water, but more on the side of international water law. Because I mentioned in my speech about the two global water conventions that are no framework agreement encouraging states to adopt agreements. And there we can see really that even when the UN Water Courses Convention was not yet entered into force, and even if there is not a clear obligation in the UN Water Courses Convention, for the UNEC Water Convention it's a little bit different. We see that the states at the basin level, they follow this recommendation of global agreements to conclude agreements at the basin level. So, for example, in Europe, after the adoption of the UNEC Water Convention, we had specific agreements on the protection of the Danube, of the Rhine, of the Meuse, and in Africa also we have a lot of agreements that have been adopted at the beginning of the 2000 on the Senegal River, Niger, Lake Chad. So these if you read these agreements, you can see clearly the influence of the UN global frameworks. So I think here it is also there, I think, a kind of constructive dialogue, a constructive dialogue between these global water conventions and the river basin agreements that follow the principles that are stated in these global treaties.
Perhaps
Wonderful.
I can quickly add to Mara's that maybe in a more macro level point of view, one of the things that has shackled the capacity of many states, especially developing or least developed countries, is the fact that they lack resources. And the a main reason why they lack resources is indebtedness. So they have to collect resources and money to pay debt. Now, in that context, so they don't have provision. In Laos, for example, a neighboring country to Thailand, I work in an organization that provides loan to them. They don't have drinkable water everywhere, and that's very alarming. So I found out that so when we work on in the context of the UK, for example, we pointed out that UK having this leverage vis-a-vis World Bank and the IMF must make sure that it must use its membership as a leverage in these organizations to make sure that when it's possible, they must provide loan forgiveness to these developing countries in order for them to have enough or sufficient resources. We talk about maximum available resources, right? So indebtedness leads to the lack of resources necessary to carry out many missions, two of which are, of course, provision of food and water. So at a higher macro level that we can't pinpoint, there is this point on maximum available resources that you must also address. Thank you.
Thank you, both of you, for your responses to that question. So we only have about 3 minutes left, so I just want to turn the floor back to each of you for any last thoughts you have before we finish up and let these students get to their next class. Mara, would you like to go first?
Yes, just not to follow what he said, Seree. No, I would like to mention the role of the Asian Investment Infrastructure Bank. So I think that it is not a very well known, at least here in Europe, international financial institution. But I think that this bank can play a role exactly for supporting the access to water and sanitation, what we call the WASH services, because the water, sanitation, health services and hygiene are linked. So I think that the issue of insufficient financial resources for providing adequate and safe access to water. It is a very important point that multilateral financial institution should not forget, and no new institution like the Asian Investment Infrastructure Bank can help to fill this gap.
Thank you, Mara. Seree?
Well, 2 points perhaps. One is that if you draw a matrix on water and food interdependency with one another and also with other issues, I think one of the reddest areas would be climate change. And you need to pay attention to that as well. Things are developing quickly in that front. The other one that I'd like to say is that I'm glad to hear that a member of Human Rights Committee is part of the as a member of Duke Law School. So actually that adds to the rich, would be great to have a discussion with him before you so we can exchange views, because these two committees, the Human Rights Committee and the CES, work on different themes with different modalities, but overall we monitor two sister covenants with the view of making if not immediate progress, progressive realization.
Great. Thank you so much, Seree. Thank you to all of our members who joined here in person and online. And let's give a round of applause for Seree and Mara. Thank you guys both so much. Thank you so much for joining us. It was really a pleasure to have you here, and I know our students got a lot out of it.
Thank you.
Have a great evening, both of you.